town in Nebraska. And yeah, the red polyester is intoxicating. But anyway, we have a new coach, Scott Frost, and he was at Nebraska when I was there when we won back-to-back national championships in the mid-90s. It's kind of been fun. He was a receivers coach and offensive coordinator at Oregon for a number of years, and he's kind of the great white hope. But with that, it looks like my pillar of time is done, and I'll let these guys introduce me. So thanks for coming.
You have your own stand-up act, right?
Oh yeah, it's terrible.
Absolutely.
Unless you're drunk.
Good morning, everybody. I'm looking around. I kind of know just about everybody here. I'm Kim Mitchell with Chicago. No, I don't want to do that. Do I need it? Yeah. Okay.
What? What'd you say?
You know what? I hate using microphones. Anyway, my name's Kim Mitchell, and I'm with Chicago Title in the Lake Oswego office. So thanks for coming here on a Monday morning. I've been friends with Kevin for quite a while, and we kind of go back and forth and talk about some, different things that are in the real estate market and some challenges and what he sees on the real estate litigation side and everything. And so he's very excited about teaching this class. This is the first time he's done this for you guys, this class, the PowerPoint and everything. So I really appreciate him quite a bit. He's an amazing attorney, a real estate attorney, and so he's always your go-to. One of the things that I love to do, you know how much I love doing classes, and it's not just for filler, it's not just to give you a credit hour, but to really give you information that's going to not only help you in your business, help your business grow, but also to keep you guys out of trouble, because that's one of the things also that your principal broker wants you to be able to accomplish. But also it's to be able to give you guys vendors and resources that are really, really good for your business, that make you guys shine as well. So there's no way that I would ever put anybody in my team that I don't think would be a great resource for you. So Kevin being one of them, and also David Bunker at Directors Mortgage. He has also helped us sponsor this class today. And we work with him as well, and he's got great integrity. People know him around the industry of being, such a great loan officer and everything. He's got lots of knowledge, and so also we're partnering up too with Kevin, and so he really thinks that he's a great attorney, and that's why he's here to support us as well. So I'm going to go ahead and give the microphone over to David Bunker. And for you guys that use Chicago Title, we really appreciate it. It helps me to be able to do things like this for you. And this is one of the things I really enjoy. The other thing is working one-on-one with you. And I've said over and over again, I don't know how many of you have Chicago Agent One app on your phone. I want to see you guys download it. You don't need me to get you to download it. Just put it on. It's an app, Chicago Agent One. It has so much stuff that can help you in your business. And not only is it in English, now they've translated a lot of the stuff into different languages as well. So just go ahead and give me a call to help and support you with that app. So with that being said, I'm going to turn it over to David. So thank you so much.
Thank you, Kim. Good morning. My name is David Bunker with Directors Mortgage, and I want to give a shout out to Kim Mitchell from Chicago Title and my partner AJ Crawford here for putting the class together today. Yeah. What a great room, and you're going to have some great information from Kevin here shortly. So just a couple of housekeeping things. Who likes loan documents getting to escrow before close date? Anybody? Okay, well, on average, the last 3 years, my loan documents with my team have gotten to escrow on average 10 days before scheduled close date. So, and that's honest God truth. In the last 2-3 weeks, I've had a couple that docs were out 14, 15 days early. And these are, 30, 35 day closes. So, in some cases, and if we need to, we can close in 15, 20 days with the right conditions in place. So fast closings are important, not just because they're fast, but because they make things easier on our clients. They make things easier on escrow. They make things easier on you. So if you are looking for a good lender solution and the execution of loans is important to you, which I hope it is, we'd love to chat with you more about it and what we do and what I call it our secret sauce is on how we do it. In a nutshell, is we do the work early in the process with the client, and that means, if possible, before they're even in your car. And that's really the key to everything, is to prepare your client for that home buying process. And then after that, it's not really rocket science if we're doing a good job up front. The other thing on loan product side, we have a new loan product which normally conventional financing is minimum 3% down. Okay. Well, we have a new program with a little second mortgage that we can get up to a 4% second mortgage. This is a great loan. The client comes in with 1% down. We take 2% of the 4% loan and we can use it for down payment. So it's essentially a 1% down conventional loan. But then I have another 2% available to cover closing costs if needed. They don't have to use it, but it's available. So remember Chenoa? Everybody remember FHA Chenoa? I call it my last resort loan, where there's people that need to get into a home for various reasons. And Chenoa was good. It's 100% FHA. A little expensive though. And it may be right still for the right conditions. Of course, we want people to come in with down payment, but not everybody has gift funds available from family, etc. So we have a lot of fantastic loan programs. If you'd like a one-on-one to get a refresher on what's out there and what we can do, get a hold of AJ or myself, and we'd be glad to sit with you. So on to the most important things is Kevin ID. Sitting here, has some great information for you today. And Kevin is currently on the board of arbitration and mediation, and he's one of the top 100 real estate attorneys in the country. So you're in good hands today. And he's an expert in contracts and landlord-tenant law, HOA and CC&R rules, mediation, arbitration. And today's class is on disclosures. So with that said, here's Kevin. And thanks for attending today.
Thanks a lot, David. I can speak loudly, but if anybody in the back can't hear me, raise your hand throughout the course today. I'm Kevin Ike, like I said, Nebraska Cornhusker. That's where I grew up. My parents lived. They've been married 50 years. They had 5 kids, 4 boys, and somehow they stayed together for 50 years. And that was a tough one. I was a middle child. I got arrested. Made me want to be a lawyer. Expelled from Jesuit high school, but I like people. I like to come around and see. I've got at least 3, maybe 4 people that have heard me speak before, so I apologize now. And you got to listen to me rant on for a while. This is a brand new class for me, but this is actually probably the most primary area of my practice is real estate litigation, construction law. So this will be the easiest one for me to teach. What that means is I'm going to talk too much. I'm going to talk too fast. I've got way more material than we can cover. So I usually take questions as we go. But today I'm going to try to save until the end, because being the first time I've gone through these slides and this material, and being as though I know a whole oodle bunch about this. I mean, I could speak about real estate litigation and disclosures specifically for probably at least a week. So we'll try to get it into 48 minutes.
Okay, I'm not asking a question, but when we started this, you said that, and I just wanted everybody to know, that 60% of your litigation business is because of disclosures, right?
Yeah, at least. We have disclosure cases in all kinds of transactions, and that's where people get sued. And the funny part is, in your transactions, in my experience representing realtors, buyers and sellers, I would say out of the transaction, when you sell or buy a house, you spend about maybe 2% of your time with the client on that disclosure checkbox form. They almost make it too easy to check these boxes, unknown, okay, we're done. That's what comes back to bite you. It's not the 47 million pages of loan documents. It's not the offer, acceptance, counteroffer. Those disclosures that just get filled out sometimes by an agent. Sometimes, yeah, I don't know, just put whatever you think. That's where we see the nitty gritty, and we spend days and days in depositions. So this is a topic that we see quite a bit. And I've got a case study at the latter part of my presentation of a case that just went to arbitration that I represented one of the parties on. I'm not going to tell you which one, because I want to have you guys take a quick look at the facts And I'm going to take a poll of hands on who would have voted for the buyer, who would have voted for the seller. Now, this is a weird captive audience with your own prejudices. And then I might tell you how it turned out, depending on the vote. But one that I just got a verdict on, and it's a fair amount of money. It's not a huge case, but it's just perfect, it's current, it's relevant, and it relates to a disclosure about an easement. So with that, let's talk a little bit. Each of these coffee cups I brought, I drank a cup out of each one before I got here, and 5 cookies, fresh off a guy's mountain bike weekend that I do every year. That's a memorial for a good friend of mine from Nebraska that died of brain cancer a year and a half ago. And so, needless to say, good guys weekend, but Monday morning class after a guys weekend might not have been the best scheduling idea. So if I am a little slow, that's why. But in any event, this is an introduction. It's about me. You already heard enough of it. I was a prosecutor in Nebraska before I moved out here 20 years ago. I got sick of locking my friends up. So I had to get out of town, moved to Portland, and been doing civil litigation ever since. I'm the kind of lawyer that likes to go to trial, which is kind of a dying breed nowadays. Most cases settle, or trial attorneys don't know where the courthouse is, but that's something that I like to do. I sit on the bench bar committee with the judges out of Washington County. I arbitrate a lot of cases as the fact finder, the decider. Mediate cases. If you ever get in a dispute with your neighbors about where the fence line is and you want me to mediate that, I'll try to get it settled for you. And there's some other stuff. I'll make these slides available to everybody through Kim and AJ, so if you need them, or you can email me. I left a lot of cards, and I'll definitely make these available, so don't worry about taking notes. So, overview of today, we're going to talk about this stuff, which is the ORREF and PMAR disclosure forms. You guys probably have seen these documents a lot, so we'll talk about them in some of the sections. One of the things I think that'll be a good takeaway for you guys, I hope, is I'm going to focus in on the critical ones that we spent a lot of time litigating about specifically. And we're going to talk about those specific to how these things you need to pay a lot of attention to, because this is where the lawyers get involved, and then $6 a minute were pretty expensive. So we're gonna talk about that. Title and marketable title, we'll talk a little bit about that. And defects, with the building, the title, the various parts of the product that you guys are selling. Boundary disputes, easements. Like I said, this was the lawsuit I just finished. Was about an undisclosed easement. Zoning, leaks, moisture, mold. We are in Portland, Oregon, which the Indians call the Willamette Valley the Valley of Death, because we have molds and funguses and slow-moving dogs grow mold around here. And our buildings just take a beating. Back in Montana, Nebraska, wherever, these things dry out in the winter. You think you have these harsh winters that beat up a building, but the benefit of a harsh, cold winter is it dries out, and so you don't have this moisture like we have in Oregon. It's the worst I've ever seen. We kind of set the stage nationally for construction defect cases. Because, windows leak, decks leak, they cause mold and dry rot, property damage, and it's very expensive to fix. And then class action settlements and claims. You guys are familiar with the LP stuff. The people that have been doing this stuff for decades. EFIS, Drive It. Some of the class action Chinese drywall. We've got plumbing litigation. There's a lot of class actions about building products that need to be disclosed. Some people filed claims, took the money and ran. Some people did repairs. And that stuff just gets brushed under the rug. But there's a specific disclosure form, checkbox, that says, are there any materials that have been used in the construction of this house that have been involved in a class action? If so, was there a claim? If so, were repairs made? And a lot of people don't know, right? Unknown is a perfectly okay answer. I would way rather have people click unknown all the way through those disclosures. If I'm defending a seller that's made a bad disclosure and he clicked unknown, and by the way, there's nice language, which I've got on the slide, a snapshot of the actual language that says buyer do their own due diligence as is. That gets you out of jail free if you click unknown. If you click no based on your actual knowledge, you're going to be in trouble. Do I have actual knowledge of something? That means I went and did the research. Okay, and this is what we litigated, and we'll talk about in the case study is
I have actual knowledge that there are no easements on this property. I have actual knowledge there's never been a class action. For me to make that affirmative representation that I know for sure that there isn't a problem, I gotta say I went and did some research, right? If I don't know, I'm unaware of any class actions, that's a totally different answer than I know there are none. It's like if I go to my doctor and I say, I got this mole, and I think it's getting bumpy, lumpy, it's changing colors, and doc, do I have cancer? And my general care practitioner says, no, Kevin, that's not cancer. Okay, what do? I go home and I rest easy. Hey, I had this problem, I have a lump, I have whatever, I have this cancer. Doctor said I'm fine. I'm not going to go see a specialist. I'm not going to go to a skin doctor and get it tested. I'm not going to have a biopsy. And then in 2 years when I die of skin cancer, guess what? By the way, I'm mad at my doctor. He's made an affirmative representation. I would have been way better off if he said, I don't know whether that's cancer or not. Kevin, why don't you go ahead and go to a specialist and have a biopsy, and then it's positive and I'm fine. They cut it out and we're done. Same thing with a house. I don't know whether there's an easement or not. Versus, no. I click no, there is no easement. Well, I wasn't aware of any. Well, did you look at your title report that you got at closing 3 years ago when you needed to refinance? Because it says there's a private access easement 12 foot over the easterly section of your property. That's what we're litigating about here today. No, I didn't do that. Think that would have been a good idea? Did you understand that my client who bought the house was relying on your representations that there were no easements in deciding whether or not to purchase the property and what price to pay for it? Think that would have been important information? Yeah. What did you do to assure yourself before making that representation? Nothing. Well, if you would have taken the time to look at your title report when you bought it, in there, went on the plat, it's in there, it's available on Portland Maps. On the refinance 4 years later, a year and a half before you sold it, it's in there. In your appraisal, any boundary disputes or easements? Yes. But you told me there aren't. So, these are the things that we look at, and when you're going through documents with a seller and you're just clicking yes, no, maybe, don't know, or your buyer that doesn't really read these, hey, here's your standard documents and DocuSign here. What do? We look at our little phone, finish. You have a completed document. You know, and I buy houses with my phone. You don't read those, but you need to. Because you don't want a guy like me charging you $350 an hour to read them and talk about them. So we'll talk about special disclosure considerations for condos and planned communities, the condo questionnaire. Lenders are pretty excited about those. We can spend a day on that. So I'm going to give you enough to know that you have an issue today, and what we call that is issue spotting, and that's when you know that you need to get some help. You need to call me or a competitor of mine and be able to say, hey, Kevin, you mentioned something about this, and God, it's coming up in this transaction, and I don't think it's a big deal, but tell me I don't have skin cancer and I won't get a biopsy. So common practices and then best practices to avoid risk. One of the guys on my guys' Mount Bob weekend is a real estate insurance guy, and so when I was putting this presentation together yesterday, I said, well, hey, when you write risk, he's in California, he's a broker, and he does a lot of different insurance stuff. And what are you looking at when you're selling insurance to people that are essentially buying a house? And he's in a big fire zone in Tahoe, by Paradise, California. He's about 20 miles away. And so he told me about things like distance to the ocean, earthquake, flood, and so some of the things that maybe we can do in a real estate transaction, because those are questions on the disclosure about, from a risk perspective, what you might want to think about. So typical disclosure lawsuit procedure, that is a mouthful. First of all, you're going to have this form agreement, your ORREF, your real estate sales agreement, your RESA agreement, and that's going to say mediation. If you get in a fight with the buyer, the seller, the realtors, you got to go to mediation first. Okay, mediation is something totally different than arbitration. I teach another class, a couple folks here have been to, that's about mediation and arbitration. Mediation, you're trying to settle the case, so you got to go there first. A mediator, like me, full-time neutral, sometimes a retired judge, usually an attorney. We sit there and we try to get you to settle the case. So we go with the seller and we say you should pay some money. We go with the buyer, you should take less money. Everybody settle, because if you don't settle here today, you're going to end up in depositions, subpoenas, litigation, arbitration, trial, expensive, everybody loses but the lawyers. So, what they do is they say in this real estate sales agreement, the ORREF, it's very specific. It says you gotta go through mediation first. And if you don't settle at mediation, it goes to arbitration through Arbitration Services of Portland. Arbitration is trial. Okay? Arbitrator, who I arbitrate cases, I also mediate cases as an arbitrator, as a mediator, and as a lawyer. And the difference between an arbitration and a mediation, and it's significant, so don't confuse these when you're talking with buyers or sellers or other people. A cocktail party is an arbitration is trial. You don't settle at a mediation, the mediator doesn't say you lose, you win. They don't get to do anything. Mediation is voluntary. Mediation is settle the case. If you don't, you go home and then you sue each other and you go to arbitration. Arbitrator makes a decision, an arbitration award, and you register that with the court, and it's a judgment. So the arbitrator says you lose, you win, and you pay them money. Now, the reason you gotta go through mediation, I had a seller that said, I didn't do anything wrong. I'm not going to mediation, it's a waste of time. I gotta pay you to go. I gotta pay the mediator, because the parties split the cost of the mediator and the arbitrator, and I'm not gonna offer him any money. I don't wanna go through that. I said, okay, well, if we read the sale agreement, right? You don't go through mediation first, and you win at arbitration. You don't get your attorney fees paid by the other side unless you went through mediation. So, I have people that say, I'm not going to mediation. I'm going to win. Take it to trial, arbitration. We go to arbitration, we win. Say, great, the loser's got to pay my attorney fee. Says that right in the contract. Prevailing party attorney fee provision. Okay, loser pays winner's attorney fees. Unless you didn't go to mediation and try to settle the case. So that's kind of one thing that I like to have people think in mind. By the way, disclaimer, this is the first time these slides have been seen, so typos are going to be in there. Arbitration Services of Portland. So that's who the Oregon ORREF Real Estate Sales Agreement, that's who needs to administer arbitrations. And that's just a private company in town that you pay a filing fee. They have a panel list of arbitrators, okay, that both sides are going to get. And you get to strike off 2 names. These are attorneys, you get a small bio, I'm on their panel. So I hear arbitrations that I'll make the decision, or I mediate these cases where there's a real estate transaction that goes bad. And then you rank the other arbitrators, and both sides are doing this, right? So you get to have an input. It's like jury selection. You get to have an input on who's going to make the decision in your case as the arbitrator or the private judge. That's critically important. The folks that are here that have heard my mediation arbitration talk about the considerations that you want to do when you're choosing your arbitrator, or you don't get to choose them. You can stipulate with the other side who you want, but more often than not, I get rid of the people that I think are friendly to the buyer or the seller. And in my world, that's the plaintiff, the claimant, the person suing, right? Yet the arbitrator, 2 of them on the list, sue people for a living. They spent 30 years as a plaintiff's attorney. They file lawsuits. They're going to be sympathetic to the person that's filing the lawsuit. Conversely, if I represent the, typically the seller that's being sued for bad disclosure regime, I want the defense attorney, the defense-oriented, the public defender-oriented arbitrator. Because they're going to see the evidence my way. You can't get that prejudice out of your head as an arbitrator. It's very hard. And so there's some considerations there. You can use various other providers, even though your documents call for Arbitration Services of Portland, ASP. You can stipulate with the other side to use somebody. I administer my own arbitrations for people. I also administer through ASP. I'm one of their panel arbitrators. AAA, American Arbitration Association, and so it's kind of like having the doctors that can practice in each hospital. Kind of a similar thing with arbitrators. So the first step is to request mediation, right? If I have a problem with the seller or a buyer or my realtor, I'm going to go through Arbitration Services of Portland and request mediation. And then they're going to assign a mediator. And we're going to go through this mediation. If it fails, I'm going to file what's called a statement of claim. That's a lawsuit in arbitration. It's called a statement of claim. In a lawsuit, it's plaintiff and defendant. Plaintiff sues defendant. In arbitration, claimant sues respondent through a statement of claim. Same thing. It's just arbitration is private. That's what's required, right? We don't get to go to court with a botched real estate agreement case because your contract, real estate sales agreement, calls for arbitration, mandatory binding arbitration. You're going to go through discovery, so that's things of documents, you know, all those emails that you sent to the other realtor on the other side that you guys are buddies and golf partners, and you go out and you drink tequila together on Friday, and you talk about your buyer or your seller that's crazy, and just do me a solid here and a favor, buddy, because blah, blah, I've seen those emails, and I've seen them, and I've seen them, and I see them in depositions, and I go, why would you ever send that email? Well, it was between me and him. We're friends. We're brothers. We're sisters. What? Nightmare. Then the realtor gets sued because the buyer says the fix was in. You guys wanted your commission, and you conspired against me when the seller is not my friend. You're supposed to be representing me, or worse yet, a dual agency. Right? This should be illegal. I can't represent the guy that I'm suing. In my cases, I can't represent the seller and the buyer. Why can you guys represent the seller and the buyer? It's a horrible idea. Third-party subpoenas, so anybody here that runs or is a principal broker has gotten a subpoena, hopefully not from me, that says give me your file. You know, and those are important. Those are the emails in your outbox and in your inbox. So more often than not, when I get discovery from a buyer's agent, and it has the email that they sent to the seller's agent, and I subpoena the seller's agent, and the seller's agent doesn't have that email. It's like, well, I can see you got it. And he told me he gave me all documents, and Gmail keeps emails for like 27 years. And so where is it? And then you look stinky, right? Did you delete it? So when you send an email, make sure whatever you say in that email, you were prepared to sit in a deposition under oath on camera to talk about what you really meant when you sent that email. Jokes do not come across very good in the written form of the, you know, you don't want to call a seller a neophyte. I had that in an email. Had to look it up. I'm a neophyte, but by the way, you call him an idiot. So we're not going to do that. Arbitration, we talked a little bit about those topics already, and so like I said, because we're going to be tight on time and I can only speak so quickly, we're going to get through this. I want to spend a little time on this case study, just selfishly. I want to know what you guys think. Disclosure lawsuits, marketable title. Read the title report. Read that thing. Read the verbiage in the title report. Read the liens. Read encumbrances. Read the plat, which don't rely on that plat if you have some inkling, because you read the bottom, and I've got a plat in here that's attached to the title report. It's largely worthless. It's some Geo Advantage aerial. You get a better plat on Portland Maps. You get a better plat if you go down and see what's recorded with the county that actually shows things that encumber this property, and it's very different than the one that your title has just attached. And it says right on the bottom of the plat on the title report, this for information purposes only, not to be relied upon, blah, 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 right? And this became a significant issue in my case study. Appraisal. You know, this title report, you got liens, tax liens, construction liens, attorney liens. A lot of times people will record a lien on a property, a contractor, a material supplier, and then they get paid. And then they never file the lien satisfaction with the county, and that lien's just floating out there. I deal with this all the time. Nobody even knows about it because they never filed a lawsuit to foreclose on the lien, right? There's no lawsuit, there's no judgment. But that lien's just encumbering this marketable title, and it doesn't come up until closing. And it's paying. And the seller's required to convey marketable title, and that's why you have title insurance, because the title insurer is guaranteeing that this title is marketable, it's able to be transferred. Boundary disputes, those are nasty. Leaks, moisture, mold. What to disclose if the seller had prior issues or repairs, non-permitted, and remodels. I am sure that people have dealt with this issue, and it's dicey because you don't want to spook a buyer, but you got to disclose when things aren't exactly done according to the books, right? And we don't want surprises, because surprises are dashed expectations. Dashed expectations a lot of times are lawsuits. And so the fact of the matter is, I would way rather have people disclose. And then you put the burden on that buyer to do their due diligence and contact the contractor that did the unpermitted work. You know, in the disclosure check boxes, as I'll call them, has the roof leaked? Yes or no? They changed that language. I was involved with the folks that put together the War Rep forms. Is this issue comes up all the time, and it can be as a basement leak, as a roof leak, but let's take the roof. Has the roof leaked in the past? Yes. I had a roof replacement right after that. Complete roof replacement, brand new roof, new roof, right? They changed the form, and in most current versions of the form, and some of us are using the current version of the form, some of us aren't, say, does the roof leak? Okay, no. Brand new roof, right? Does buyer want to know that the roof had leaked in the past and been repaired? I want to know that because if you go up in the attic, a lot of times they just put a layer of comp roofing on top of the old leaky roof. That meets code. And they've done nothing to the insulation in your attic that had water on it. Maybe they painted the drywall where they found the roof leak from the underside. They've done nothing to the roof sheathing, the plywood that makes up your roof under those shingles. That's rotten. Walk up there, it's soft. They didn't want to fix it because they have to tear off the shingles. We're selling this thing anyway. It's going to look nice with a brand new roof. I sign my disclosure that says the roof doesn't leak today because there's a new roof. And then I find out when I buy this house that the roof had leaked. They had done water damage repairs. There's mold in the attic, right? And now I'm upset. And then I call Kevin. And Kevin says, sue the bastard. And I'll get my attorney fees when I win. Let's go easy. So, you know, these are things that we just click that box. No, roof doesn't leak. We're good. It's brand new. Paid $15,714 for the roof. So those things, I mean, seriously, you should go through this disclosure with your clients. Every checkbox, you should sit down and talk about it, and no one does it. You send it to them, they dock it, sign it, you barely read it. Let's hold it till the end if we can, because I got a lot to get through.
Super relevant. I've had several principal brokers tell me specifically to not sit down with your seller and go through the checkboxes with them if they have questions. They can contact their real estate attorney. We are not supposed to even talk about, oh, it says that it leaked now versus the old person said it never leaked.
You know that I'm not going to trump your principal broker on what they say because they're looking out so they don't get sued.
Yeah.
Well, I will tell you, 60% of my litigated cases are disclosure cases, and when the buyer, who's a layperson, buyers put their faith and trust in you as their realtor. They absolutely do. My realtor didn't tell me to pay attention to the disclosure. Then we sue the realtor. So absolutely contact a real estate attorney, and that's in the language of the real estate sales agreement. No one ever does because they don't want to pay. But, you know, I think a very good idea would be to put that in an email to your client to say, look, these disclosures are important. You should consult an attorney. It says that in the real estate sales agreement, and so you're not telling them anything, but you're highlighting them to that issue. Because these things turn into $50, $60, $100, $200,000 problems pretty quickly. Yeah, that is a great point, and I have heard principal brokers say that, and I can't blame them because, you know, they don't want to get sued. But at the same time, that buyer or that seller is going to say, my realtor didn't point out that they clicked yes that there had been this issue. I've assumed this was a standard disclosure. Checkboxes. And it's amazing how many people do not read it at all. Inspections we can talk about. Class action lawsuits and claims. So Louisiana Pacific LP siding, we're not seeing as much of that, but it's still out there. A lot of people take the money and run. Eat this, drive it. There's a CertainTeed that looks like Hardy Plank right now. That CertainTeed's a manufacturer of a knockoff Hardy Plank fiber cement siding product. We did a lot of litigation about this. CertainTeed's, when they sold about 6 years ago, put aside $104 million. Sounds like a lot of money, but it's this bad siding's on 300,000 buildings. The class action ability to file claims, it's called fibercementsettlement.com, ends in August of 2020. I filed a lot of those class actions. It looks exactly like Hardy Plank. We come up to a house and we see fiber cement Hardy Plank, and we call it like a Kleenex. It's a tissue, Hardy Plank, fiber cement siding. We're excited about that because Hardy Plank doesn't rot. It's not LP, it's not cedar, it's bulletproof. It lasts 50 years, it's got warranty. It may be the stuff that was subject to the class action, and again, it's like, well, no, it's not subject to a class action. You should click I don't know. Because hardy plank may be certain teats and plank which may have been subject to class action if it was installed between 2006 and 2013, which they installed a lot of it in this area. Chinese drywall, roofing. So one of the other buddies on this mountain bike weekend is a client, is a roofer. House Camp Roofing. Anybody ever run into House Camp Roofing? Good. He's a friend, but not a very good roofer. But anyway, he told me about these roofing when I was putting this together. He was pouring Bailey's in his coffee this morning or yesterday. There's roofing that have had a lot of class actions as well. And Chinese drywall, we got plumbing.
What's Chinese drywall?
So that was a big deal, more so on the East Coast, but we've had some here. And basically it's drywall that had some bad contaminant in it, and they installed it. And the difficult part with Chinese drywall cases is when you have to replace all your drywall, now you're taking your cabinets out, you're taking your built-ins out, you're taking out all your fixtures, and it gets really expensive. So I've had a half a dozen Chinese drywall cases. And they're a little bit difficult, and they're kind of the big thing within the last 5 years, particularly in the Northeast. But yeah, it's not something that I would guess that you would run into, like roofing or siding, but you know, you just never know.
Why do they call it Chinese drywall?
Made in China. You get a coffee mug for me picking on you don't get the hat yet, though. Alright, so the catch-all is one that is a big deal. This is the last disclosure checkbox, and this one, by the time you check all these boxes, and it's 4 pages, people ignore this one, but this is a big one, and it's in my slide. I got a snapshot of it, so I'll show it to you. But it's full disclosure by seller. It's the last one, and it says, are there any other material defects impacting the fair market value that a potential buyer should know about? That covers everything. This was meth lab. My grandma died in that chair. You know, I want to know about all this stuff. And so if I don't have a misdisclosure or an inaccurate disclosure on any specific question, this is what we litigate about all the time. And you know, it's very broad. And if so, please attach an explanation. And that's where I say, yeah, we had this issue, disclose, disclose, disclose. It's like when I applied to be a member of the Oregon State Bar, and I called my lawyer, hey, when I was 12 and I got busted shoplifting, do I have to disclose that? And I go, yes. And I go, oh. It was batteries. You know, but it's disclose, disclose, disclose. Because if you disclose it, and it's not a big deal, then you're never going to get yourself in trouble. If you don't disclose it, you're going to get yourself in trouble. It may not be pertinent to you. It may not be a big deal to you. They let me in the bar, even though I stole some batteries when I was 12 in 1979. But, you know, whatever. You just disclose it and be done with it. And then it's off your plate. So that's the catch-all. These are all the other disclosures. Termites, well, septic, settlement, fill, prior repairs, hazmat, drugs, death, crime, mineral rights, neighbors, crazy neighbors. I do a lot of crazy neighbor cases. Crazy people living close together is great work for lawyers. The Pearl and those condos, oh my goodness. I had a condo, this guy, we were taking his deposition, high-end condo, you know, his HOA fees were $850 a month. No pool, no anything, anyway, $2 million penthouse condo, and he called his condominium complex a temple of hate. I've never forgotten that. It was. People hate each other. It's like, these are your neighbors, you know. Oh my God, can I borrow a cup of sugar? Please die. So in any event, so it's a balancing act, right? You don't want to foil the sale because this property's been on the market for 2 years. We got a California all-cash buyer. They don't know what EFS is. Please God, get this off my books. Got to disclose EFS. But disclose, believe me, please disclose. Special disclosures for condos. So we're going to go pretty quickly through this because this is a big deal in the condo questionnaires that lenders are requiring, are ever changing. Every lender's got a different questionnaire. The biggest topic I think that I see day in and day out are special assessments. So I get a call at least 1 or 2 a week. that say, I bought this condo. And a month later, 2 months later, a year later, we got a special assessment for $41,000 for a new siding. The seller had to know. They didn't disclose it to me. Condo disclosure forms they're getting better. But a pending special assessment is what they ask about. But before a special assessment happens, we've talked about this in the community, and we've done everything we can possibly do to avoid it, because the board hates to tell its owners that we passed a special assessment. And so it's discussed in board meetings, and HOA meetings that none of us go to, have meeting minutes, right? And so have your buyer review the meeting minutes over the last year. And in there it's going to say, special assessment voted no. Special assessment reserves are low, we need to up monthly assessments. And we need a special assessment for siding, roofing, driveway, asphalt, condos, there's always special assessments. And so you buy these things subject to a special assessment, and it's not a pleasant thing to do. Also, a lot of times when we buy condos or townhomes out of foreclosure, a lot of times there's a tax lien, a lot of times there's a construction lien, and some of those die. A HOA has a lien for unpaid monthly dues. Some of those die when you buy the property, the new purchaser. But what the tricky HOA attorneys have done is we came up with a scheme to say, okay, there's a $20,000 special assessment on this condo complex, right? I'm going to give each owner an option to either pay the $20,000 up front or pay $1,000 a month for 20 months, right? And we used to just pass a $20,000 assessment per unit, and we were done, and here we go. And you can pay in 20 months, and you get interest or you don't, because HOAs take out loans to pay these capital improvements or repairs. What we've done now, or I do, is I pass a series of serial special assessments of $1,000 a month. And so what will happen is I pass a $20,000 assessment in a series of $1,000 assessments monthly. If a bank forecloses on a property, they haven't paid 4 months, they're $4,000 in arrears. I buy it out of foreclosure, that $4,000's gone, HOA never gets it. But the new buyer has to pay $1,000. If I had passed that single assessment for $20,000 that you can pay over 20 months, that whole 20's gone. I buy this thing free and clear, no assessment. That's why I do successive serial assessments. And so there's a lot of just devils in the details. Again, you're going to spot this issue and you're going to call me. And I'm going to say, oh, this is what this tricky HOA did. Because now this buyer is going to be surprised when they buy it and they go, oh my God, I got $16,000 in special assessments. Every month I got to pay an extra $1,000. This is crap. Why didn't you tell me about this? Well, my principal broker told me not to walk you through the disclosure. These things do happen. And then, these things, smoking bans, marijuana, age restrictions, Airbnb, these are all with the governing documents of HOAs that come. They want amendments and rules to their governing documents. I had a call Friday that they don't want a adult foster care home to buy this house in the neighborhood. And it's very delicate because you can't discriminate. If I can rent my house out monthly in this neighborhood, you can. Why can't somebody buy the house and rent out rooms monthly to adult, disabled people? And they go, how do we prevent this? We don't want to foster. There's another one. Ambulances come, fire trucks come, people visit. This is a neighborhood. And so it's going to be a little bit difficult to not get into trouble and make the headlines in the paper about this nasty HOA that discriminates against old people. But I don't want an adult foster care as my neighbor. Unless maybe my parents are in there, but probably even more so not. So we're working through that. Best practices to manage risk. This is from my insurance buddy. Disclose. Think about it from an insurer's perspective, right? So, floodplain, fire risk, distance to the coast. A lot of these you don't have insurance for, earthquake insurance. I was amazed when he looked at my homeowners policies in different areas, what they exclude. If tsunami's not covered, floodplain's not covered, all this different stuff not covered, fire. You know, so check that stuff, and it's not maybe as pertinent to this situation because you're doing a disclosure, but things like asbestos, right, mold, these are all issues that these homes we come up with, and it's like, we're realtors, not contractors. How in the heck am I supposed to know whether that ceiling tile, when, where, how, what, you know, it can be a little bit scary. Historic significance, wells, irrigation, septic, again, these are all kind of hot button issues that when you're going through disclosures, there are specific check boxes that relate to these things. And water tests and wells, wood burning stoves, I mean, every building is as different as you and I. You know, I don't eat eggs or mustard. You may love eggs with mustard on them. And so every house has a story to tell, and it's sometimes a 100-year-old story. And boy, I'll tell you, it's a can of worms sometimes, and sometimes the realtor doesn't want to know, right? Because you have plausible deniability. But if you're representing your 87-year-old mother buying a house, are you going to treat her differently in this sale and protect her better than your average Joe client you've never met? Maybe you never met them in person, they just want you to represent them in the documents. Not scary, but something to think about. You know, what I always do when there has been this work, it's been a really good insurance policy for me or for a broker that I would advise is to say, yeah, there's been work done to this house. This is a flip, right? There's a lot of flips. And a lot of my litigation is either about Street of Dreams homes because they build $1 million home in 2 months. And it's all freebies from, you know, material suppliers and subs, and so they're not very well built. But you guys market them as Street of Dreams. Everybody wants to buy a Street of Dreams home. I would never, ever, ever buy a Street of Dreams home. I've litigated at least 25 Street of Dreams homes. Every Street of Dreams for the last 20 years. They are horribly constructed. Horrible, horrible, horrible. Anybody own a Street of Dreams home? Alright, D.R. Horton builds a Street of Dreams home, you better run in a Ferrari. Anybody here work for D.R. Horton? I know somebody who owns a Street of Dreams home, a D.R. Horton home, so I won't say much more.
I thought a doctor worked.
So what I like to do is I put in there at this catch-all, right, is there any other material defects that potential buyers should know about that affect the fair market value? Substantial remodel, flip. Buyers advised to do their own due diligence, including contacting general contractor, DR, whoever. And they never contact the contractor. It looks nice, there's granite countertops, there's stainless steel appliances, the wife loves the kitchen, and they want to buy it. But if they have a problem and this work was done shoddily, which in flips it always is, because they don't want to spend the money, and it looks nice, then I say, oh, we disclosed, there's all this work done, we told you who did the work, and we told you to go ask them what they did. Are the warranties transferable? Whatever. And then their claim is against that contractor and not against the seller. And so that's been really, really good. And you can cage it up, hey, I'm doing you a favor by telling you this work was done and you should feel good about it, and this reputable contractor did it, and he's great to deal with, and go call him. So this is our case study, and we have 8-9 minutes. Knew we were going to run out of time. Alright, so here's what happened. Client buys a house in Multnomah Village, and pay good money for it, and the disclosure says, are there any easements? And the seller says no. Not unknown. Seller has actual knowledge there are no easements. Turns out there was a 12-foot private access easement running across the whole side of this house. And I'll show you what we're talking about. Okay, so here is the house. Okay, this is the flag lot. Maybe you guys know Southwest Carson. This is Hume Street. So this is the house, and there's a private access easement right here. Okay, 12 foot. Actually, the house, this is 10 foot. So the house is built 2 foot onto the easement. Okay, this is neighbor that owns the easement. Okay, he accesses his property and his 17 cars right here. All right, what's he going to do in the future in Multnomah Village? He gonna partition this little sucker out right here. What's gonna be the only way to get to this house? I drive a diesel dually Chevy pickup. I'm from Nebraska. My exhaust pipe's on the left side. This is their kitchen window. Okay? I'm gonna be a foot from their kitchen window. She's gonna be doing dishes. I'm gonna roll coal. Anybody know what rolling coal is? Alright, you know. I'm gonna roll coal when I roll through there, which means you hit the gas and a big plume of black smoke we call Prius repellent. Blows into her window. This is horrible. The city shouldn't have permitted this. It's built 2 foot onto the easement. They might have to tear the house down. Okay, I'm pissed now. This is my flag lot. I got 2 little kids. I bought this. I went to landscape this area and put a shed here. The neighbor came out. There's a gate that's locked. He said you can't do it. So what do? So here it is. Right here. Driving right here. Right? You want somebody driving right there? Every day? My kids play in this. This is my flag lot. This is where my kids, this is my sanctuary, my oasis, my den. Right? I got 2-year-olds and 3-year-olds. So they sued. Okay? And I said, this cannot be. There's a gate here. Everybody should know when he bought the house. Why is that gate there? Seller says, oh, I never talked to him. Seller said he lived there for 13 years, never talked to a single neighbor. When we were out here raking and we wanted to, I represent the buyer. When we were out here, he comes out and he says, yeah, you can't do that because I have an easement. You can't build anything here that's going to impact my ability to put a road in. I said, great, will you sell the easement? And he said, no, I'm not selling the easement. I'll give you 10 grand. No. Because then, sells the easement, this lot is now worthless. Right? They're going to build a house. They're in Multnomah Village. Everybody wants to live in Multnomah Village. So, here's what was on the title report. When I bought the property, I get a title report through an unnamed title company. Easements, right? This is in the verbiage. Exceptions. Private road access. Easterly 12 people. Buyer, and we'll talk about the documents, but we got to do it in 7 minutes. But here's the plat. Okay? I don't see any easement on the plat. This is the plat on the title report. Right? Here's this, and in fact, it shows they're going to divide this lot. Right? So the buyer says, well, I looked at the title report, I looked at the plat, I didn't see no easement. I didn't read this. I got the title report for the first time of closing. The realtor should have given it to him. The email trail showed that the buyer's realtor got the title report. Within 10 days, they have to object to the title report on the sale agreement. Buyer's realtor didn't give it to the seller until at closing. To the buyer. So, here's the real plat at the county. Private access easement. Nobody ever saw this. This is what should have been attached to the title report. This is what should have been attached to the appraisal. I would have known. Right? This is what I got. Worthless. Okay? Private access easement. Hello. The seller had a title report when he bought it in 2006. The seller's title report didn't say this at all. It said sewer easement. That was it. That title company screwed up. Because this plat was already on the books. Okay? That title report had this plat. Worthless. The seller then refinanced 2 years before the sale, and that title report had this. Private road access. The seller didn't read it. The seller filled out the disclosures. Are there any rights-of-way easements? No. He had the title report that said there's a private access easement. He lied. My clients relied upon it. Clients bought the house. I heard an appraisal. The appraiser said $60,000 in diminished value of the house with that easement. If I go to buy that house, there's no easement. It's worth 60 grand more. Okay. So all this stuff, pay attention to. This is your real estate sales agreement. Disclosures in this form are based on seller's actual knowledge. Do you have actual knowledge there's no easement? No. You have actual knowledge there is an easement because you have constructive inquiry knowledge based on your title report. When you refi, that said private access road easement. Oh, I didn't read that. That was from my bank. Totally normal. 90% of buyers would have done the same thing. Sellers, same thing, right? But this is what Kevin does when he gets these facts. I'll try this case, took a day, it took 8 hours, try this case, I'm gonna try it in 3 more minutes. Alright, as is, this agreement is intended to be legally binding contract, it is not understood to seek competent legal advice. Seller, did you do that before you click no, there's no easement? No, didn't think I needed to. Realtor didn't tell me I needed to contact an attorney, I hate attorneys. As is, okay, all defects known and unknown, okay? This is the other provision that none of us pay attention to, but it's in the, buyer has not relied on any oral or written statements made by seller. Wait a second, the disclosure, I'm relying on every written statement. I'm relying on the seller to tell me. Well, no, buyer signed this contract that says I'm not relying on any written statements by the buyer or the seller. Well, then what's the point of the sales agreement? What's the point of the disclosures? Right? Buyer fully understands, buyer acknowledges, not relied, and they'll do their own and nothing, anything, okay? And here's the title insurance. Seller buys title insurance, the title report. Buyer gets the report, right? And then buyer has, it's either 5 or 10 days to object, right? Approval, review and approval of the report. If they're not, if this title report is not fully understood, buyer should immediately contact the title insurance company. Okay? Buyer and seller's agents are not qualified to advise clients on specific legal or title issues. Get you guys out of jail. Alright. So buyer acknowledges, they pay diligent attention for defects, this stuff. These are all language in this 47-page sale agreement that makes sense or matter. Right? This is where the gold is. This is what you should highlight and point your attention to, and you can have these slides because this is magic. This is special sauce in David's words. Alright? So, disclosures in this form, actual knowledge, we talked about that, seller signs it. Signs that. Full disclosure, are there any other material defects affecting this property or its value? Prospective buyer should know about it. Yes, describe. No. I want to know about the easement. I want to know that the roof leaked 47 years ago. I probably should redact his name. So, there's us, come see us. We're in Tiger by Burgerville towards Moreland Plumbing. But before we close, we've got 0 minutes. In that case, okay, we sued for $60,000. The loser pays the winner's attorney fees. It took 9 months. My bill, I sued. I was the buyer. My bill was $35,000. The seller's attorney was $35,000. The arbitrator charged $2,500. Our expert charged $3,000, our appraiser. So if you do your math quick in your head, you're working at about $80,000. Plus the $60,000 in damages that are the basis. So here we are. We're at $140,000 or whatever, right? So who thinks that the seller was okay and they should not be found liable at all for saying there are no easements, even though it was in their refinance title report 2 years earlier? Raise your hand if you think the seller should not be held liable. Oh, wait, one person. Raise your hand if you think the buyer should have gotten awarded money damages. I'm not saying $60,000. Great appraiser, I don't know what the value was. He said 60. Raise your hand if you think the buyer is entitled to money because that seller did not disclose the easement, even though, hang on, even though the buyer had this title report that says private road access easterly 12 foot, and the buyer says, I accept buyer's review and approval of the title report, and they're not relying on any written representation or oral representation from the seller. Who thinks the buyer gets money here? I changed your mind. I can sway this crowd anywhere I want to go. God, I must be a good attorney. Buyer lost. I've lost 2 cases in 20 years.
Lost on the basis of what? On what basis?
Buyer's not relying on any oral or written representation and is advised to do their own due diligence. It was in the buyer's title report. Clearly listed. He said he didn't read it. Didn't pay attention to those written. He said he looked at the plat. In the title report, he said he looked at this.
But there's a 12 right in that corner. See?
Yeah.
Right there.
I mean, there is. There's enough.
Yeah.
Right? And basically the documents, and it was a close case. But guess what? Now this buyer, who happens to be my wife's coworker, he went to Cornell, he's an engineer, he's a smart guy. I told him to walk away early on. He's got to pay me 35 grand. He's got to pay the other side 32 grand. He's got to pay his expert 3 grand. He has to pay the arbitrator $2,500. He's got to pay prevailing party fees of $600. Filing fees with arbitration services in Portland of $600. He's in this thing 85 grand. And oh, by the way, now when he sells, he's got to disclose, are there any easements? Right? You think he can say no, there's no easements now? Right? Right here? Are there any easements?
And he could say, explain it.
Right. And so now the buyer says, I don't want to buy this house. I don't want this. No. That's the whole advantage of this. His lot here is privacy. You come in a flag lot and you got this nice yard. So that's just one little, I gave it a 50-50. I told him 50-50. Like I swayed you guys buyer seller, right? I've tried an excellent case. We subpoenaed everybody's file. I over litigated the hell out of this thing because he's a personal friend with my wife. I like the guy. He's got a beautiful family, wife and kids. So we're out of time, but I'll take questions.
Why didn't you go to the title company?
Yeah.
I can't talk about all those other cases that are still going on.
How come the
City never gets held liable, but the city, the funny part about that is a good question, is the city never should have approved.
Right, because it's on.
This house is built in the easement. This house is 2 foot over the easement. And so now, yeah, the builder sold it to the builder. His wife was the realtor representing the buyer and the seller when the prior owner bought it.
Yeah.
Builder's wife was the realtor. He did not disclose the easement. The builder built it 2 foot into the easement, but here's the deal. In Oregon, you only have 10 years to sue anybody for anything, no matter what. That was more than 10 years ago, so the builder and his wife, the realtor, who hopefully isn't in this room or I'm in trouble, they're off the hook because it's more than 10 years ago.
So typically driveways by city will be required to be 18 to 21 feet, so is that easement even going to be possible to be a driveway for that?
Don't know.
So maybe it's not even an issue.
I'm just trying to walk off this coffee.
Well, now I don't feel as special.
It's like a bouquet toss at a wedding.
Was it a jury?
I was arbitrator. I heard that. Yeah, I was an arbitrator, and God, it was a close call. My clients were pissed. I mean, this was an emotional case for them. Their kids. One of them was in the ICU for 62 days when she was born. She is struggles with some health issues. She's 6. She's about the size of a 2-year-old. They play in their yard. This is where they raised their family. This is why they bought the house. It was a private lot, and no appeal on arbitration. There's no appeal.
So they should check out the width of driveway rules, so maybe that'll save them.
Well, and we tried to buy it from the neighbor, wouldn't sell it. And now they're at a loss because they got to sell this house with this problem. Hopefully, the other people that we still have pending litigation against will pay. So those people, the list of potential people that are still involved are realtors on both sides and title companies. So hopefully, nobody in this room.
Why can't you go after the city?
You can, but it's a loser. I can talk about that for weeks because basically the city of Portland has their own in-house attorneys. They will spend way more, 10 times more fighting the case than it's worth because they want to send a message that if you mess with the city, you're going to get soaked. And you don't get your attorney fees when you win against the city because you don't have a contract with them. And they're in-house attorneys, they pay a salary, don't care if they pay them today or tomorrow on your case or somebody else's, and they think if they spend $100,000 fighting a $10,000 case here, 10 of your neighbors are never going to sue the city. Go ahead.
In the case of the condominium, is it the seller's liability? Can he plead ignorance that he didn't know that a special assessment had been planned earlier if the buyer buys and finds out later?
Seller has actual knowledge. Actual knowledge means you got to go do some research. Actual knowledge means when you got the meeting minutes for all the HOA meetings that you didn't go to, that you don't read, and it said maybe there's assessment, that's actual knowledge. You should have clicked on no. Always click unknown. Unknown. Always click unknown. Go ahead.
In the discussion, you kept referring to the map attached to the prelim as a plat. It's not a plat, it's the tax assessor's map for location purposes only.
Yeah, that disclaimer.
Right. And so what comes with your prelim is helpful, but not definitive of the actual situation.
But here's the deal. The buyer relied on it. The seller relied on it. Well, I looked at it. That's the plat. No, this is the plat. Exactly. And there's a great disclaimer in tiny print on that tax assessor, what did you call it, a map? Said information purposes only, do not rely, blah, 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 blah.
If they went to the county, would this map have been
Yeah.
at the county?
That's a recorded document.
So if you really care, you've got to go to the county to check out your lot.
And here's the deal, that cuts both ways. The seller should have done that when he said he has actual knowledge there are in fact no easements. The buyer should have done it when they said I accept the title report. We sued, burden of proof's on we lose. 50-50, guy suing loses.
If I can just plug Chicago Title, I'm in a situation right now where I went to Chicago Title and says, hey, we got a question on the lot, and that came to me just a couple of days later.
These good title people are awesome. They run a trio, they run a lien search within like minutes. It's amazing of the information that's out there if you have a good title person that you're nice to and maybe pays you back for giving talks. So let's take, I've got a little bit of time, so let's maybe take 5 more questions with the group and then give people, if anybody's got to leave, I won't be offended, and then if people want to dingle around afterwards and pick my brain a little bit, we'll do that. So number 1 is right here.
Please do sign the survey too and let us know, give us feedback as well.
Can you talk a little bit more about material facts that are disclosed? Because you had death and neighbors up there, and I thought material facts were just things about the actual physical property.
Well, I mean, that's where I come into the catch-all. Material defects affecting this property or its value that a prospective buyer should know about. I can fit anything in there. I can say it's got pink flamingos and a red front door, and I think that impacts the value, and I should know about that. Right? So here's where we use common sense. And here's where we disclose. And so if you're explaining to an arbitrator, me, why you didn't disclose that Granny died in the living room a week ago, that's not material. The neighbor's nuts and shoots off bottle rockets every day at midnight. Neighbor's got a German Shepherd that is vicious. And I go, well, I'm a buyer, I wanted to know that. You gotta explain yourself, and it's gotta make sense, because if it looks like you were hiding something, the arbitrator's gotta say you pay money and pays attorney fees. And we're talking about, I don't necessarily have $80,000 I want to pay right now for somebody for selling my house, right, and not disclosing something stupid. That's not gonna spook the sale. Disclose it. I always say disclose, but I'm a paranoid divorce attorney that thinks there's no good marriages out there, right? Every marriage I see as a divorce attorney is turd. All those good marriages, everybody that's got a good marriage, divorce attorney never sees one. All I see is the 5% of real estate transactions, 2% that go bad. That's every day, all day, 100% of my day, right? The good ones, where you gave them a flat screen TV and you got a fruit basket and the realtors went out and everybody was happy, I never see any of those, ever. So we've got a couple more questions. Go ahead in the back.
How do you recommend disclosing after a sale failed a home inspection?
Yeah, so that's dicey. Here's how that works. And most of you guys know this because you've been doing real estate, but if you don't, it says you don't give the inspection report to the seller unless they ask for it. I see this mistake all the time. Realtors give the seller agent the inspection report. That's a problem. Because I don't want the inspection report when I sell my house. I do not want that inspection report. The contract says, buyer, do not give me that seller report unless I ask for it. Because if I get that inspection report, sale goes through, now I got to disclose that inspection report to any other protected buyer, right? And so, yes, you got to disclose. Now you know. Buyer said, here's the 21 things I want fixed. Repair addendum. Seller says, nah, I ain't fixing them. right? In Seattle, it's interesting right now, the way the market works up there. My brother just bought a house. It's basically you buy it, give or take. You get to do an inspection, okay, buyer, but seller does no repairs. Based on your inspection, you either buy it or you don't. No matter what. No seller repairs. That's industry standard in Seattle. Because the market, it might be softening because the market's softening. But I would rather see that. Then I'm buying it. I'm a buyer. I know it's going to cost me this much to fix it, and I'm okay with those items. Right? But now it's a good question. Now you got to disclose them.
Can you just attach the entire inspection, or do you have to
Only if they ask for it.
on the seller's disclosure?
Oh yeah,
For the
absolutely.
next buyer?
That's a great idea. Yeah, absolutely.
We'll say here it is versus going through everything.
But here's what I do when I buy a piece of property. I send my inspectors out because I'm a construction defect litigator. And my inspectors find everything. We're talking FLIR imaging cams, we're talking drone footage, we're talking $100,000 contractor bid to fix problems that aren't really there. And then I say, hey, seller, I'll split it with you. I want 50 grand off because this place is going to fall over tomorrow. Seller says no. I say, okay, well, you got to disclose all this to the next buyer, and they're not going to buy it. And I got guys that'll fix it for less, and I'll take the risk, and I know what I'm doing. And if you don't give me 50 grand off, good luck selling this thing anywhere in town because now you got to disclose that it's completely screwed. Works pretty well. Anybody in here gets an offer on a property from me? I'm just going to go ahead and tell you. It's probably not a good idea. Or if you buy anything that I'm selling, there's a reason I'm selling it. It might be disclosed. Two more questions. Two more. Go ahead.
Now, this one you only have two choices, yes or no.
Yeah.
No and no. So
I know
what
it.
do you do as a seller?
Say yes and disclose everything. Yeah, draw an unknown box. No, I disclose something here. You know what I do is I disclose something trivial that's not going to spook the sale. And then I attach a sheet explaining, saying what it is, and then I say, to the extent buyer feels like they need to get contractors to look at the property, engineers, architects, or do more inspections than normal, then you should do that. And then it gives me an out. If there's some weird thing that I didn't even expect, I've got it in the language of the agreement, but then I've got my handwritten or typewritten sheet that explains more. And I said, look, I went above and beyond. I disclosed stuff I even didn't have to disclose. So I bought my building for me and Ricky, my real estate office here in Tiger, by downtown Tiger, that he practiced real estate out of. He's now a realtor at Moore, and I asked him if I could say his name, and he said no. So, he disclosed everything when I bought that building. Holy cow. It's a 1910 building. He was so smart. And he knew what I did, and I represented myself as a realtor, which is like doing gallbladder surgery on yourself with a steak knife. You can do it, it's not a good idea. And he disclosed stuff from every day he lived or where he worked out of there, he disclosed it. I said, good job. and there's been some issues. It's a 1910 house, and I took it all apart, and there's some funny stuff going on, and he disclosed enough that led me to have to look where I took the risk. And it didn't spook me as a buyer, and I'm a very, very, very scared buyer. So, one more question.
Death in the home. My understanding as a realtor is that a seller would not have to disclose that unless they're asked specifically by the buyer. What would you do?
If it's a murder, you gotta disclose it.
A murder, okay.
Death, technically no, but again, would you buying a house want to know?
Just someone dying in the home?
Would you want to know?
What about suicide?
Would you want to know?
There's a website called Dead in the House. I have a guy that flips homes, and he knows, and it's $15 to find out. And yeah, it's called Dead in the House.
But then you know when you gotta disclose it.
Yeah, well, I mean, yeah.
Unknown.
Some people don't care, and other people, other people do. So, I mean, it's not required. Just tell your buyer to go along and do it. Dead in the House.
It's like the unreasonably reasonably prudent man. It's like, how far does it go, right? So use your common sense, I think, is the bottom line, and if that leads you to an uncertain answer, call me. All right, well, thanks, guys, for coming out. That was the first time through that. Go out and survey. Thanks, Kim and David and AJ, they make it possible.
If you want to come and see cars, go ahead and get one.
Yeah, they're here in the back there.